Hello there everyone, interesting capital gains tax case today that caught my attention. I thought I'd share it with you. Basically to do with beneficial ownership. So any asset, you could basically split title between legal ownership and beneficial ownership. And the beneficial ownership is what determines the tax. Who beneficially owns the asset? Well, they pay tax on it. As a general rule. Now, in this particular case, this chap inherited a property about 25 years ago. Over here is a timeline. So, actually, I've said he bought it. That's wrong. He inherited it from his, I think it was his late mother. So he acquired it. His base cost was however many £1,000 it was for future capital gains. Got this property. So, now, this guy then went bankrupt several years later. Then, after 3 years, because way back then it used to take 3 years to be discharged from bankruptcy, I think now it's 12 months. So then he was discharged from bankruptcy, and then a few years after that he sold the property. So in the timeline, acquired it, was made bankrupt, came out of bankruptcy, and then flogged it. So this was not his main residence, so it was the principal private residence relief didn't apply. So he basically put this thing on his tax return for not a lot of capital gain, basically. And HMRC said, no, there is quite a bit more capital gain than you think there is, and it went to tribunal. Now, basically, what this taxpayer said was this. He said, look, this period here, when I became bankrupt, the beneficial ownership vested in with my trustees in bankruptcy. And then 3 years later, when I came out of bankruptcy, the beneficial ownership was passed back to me. So, and that is absolutely correct. So you can kind of see where this guy was going with his argument. The fact that beneficially, the beneficial ownership didn't vest with him for the years in which the bankruptcy proceedings were going on, those several years, because the property was with the trustees in bankruptcy. So everyone who was in that unfortunate position, there are trustees who administer that, look after the whole bankruptcy proceedings, and technically the beneficial ownership of the property vests with them. Now what happened was, obviously they didn't flog it, they didn't have to flog it to satisfy any creditors, and he got the thing back. But the point is, in the tax case, he said, look, the tax law, it's all about beneficial ownership, and for those several years I didn't have the beneficial ownership, so why should I pay tax on the increase in value in those years, because beneficially I didn't own it? And this went to the tribunal, but actually there is a clause, a paragraph in the capital gains tax law that does actually say you can discard the fact that someone else during that bankruptcy period was the beneficial owner of the asset. To all intents and purposes, the guy had the thing all the way through, hence subject to the capital gain and the uplift in value from there to there, not from, bits of it. So his case was dismissed. But an interesting case nevertheless, and an interesting argument that the guy put forward, because, I can kind of see exactly where he's coming from. So look, beneficial ownership is what drives tax, and for those several years I wasn't the beneficial owner. Yes, that is the default rule in 99.9% in the tax world generally across all the taxes, but there is a specific provision in the capital gains tax rules which says, notwithstanding that, if you are in the situation where you're bankrupt, you are deemed nevertheless for capital gains tax purposes as if you had it all along, notwithstanding that beneficial ownership strictly does vest with your trustees in bankruptcy for so many years. So there you go. So just an interesting case I thought I'd share with you on capital gains tax. If you like this video, please do subscribe, and as always, I'll see you soon.